So you guys might wonder, what is transitional work or light duty work, however you want to call it. It is temporary in nature, and it is within the employee's physician-imposed restrictions. Ultimately, it keeps the employee in the working mindset, which is statistically shown to reduce time in recovering from an injury. Many of you may not realize what transitional jobs can be. As earlier, they can be part-time or reduced hours. Medical restrictions might limit that employee from working full-time, but you can get the employee back to work part-time. Although there are some wage loss benefits paid to them because of the part-time status, again, it's less than if the employee weren't working at all. In addition, you're providing that employee, again, in that working mindset. I can't stress that enough. The transitional job can also be at a lower wage, if necessary. If you bring that employee back to work in a different position that typically earns a lesser wage, it is okay to pay the employee a lower wage. Some wage loss benefits will be paid to the employee again, even as if they were working part-time, to make up the difference, but overall, again, the cost is less and you're keeping them in that working mindset. If you have questions with that, you can feel free to contact your claim rep and discuss that, and they can walk through the options to see what's going to suit you guys best. Transitional jobs can also be in a different department or location. If you're having difficulty finding transitional work, consider moving them. This might be the only way, to get some employees back to work.
Yeah, that's right, Michelle. A couple caveats with this, though, and this is the perfect time to address the question about the rights that the employee may have to refuse work. The court essentially requires that the work be suitable. In many states, and that means physically suitable and financially suitable. Physically means, again, within the doctor's imposed restrictions, and financially suitable, in Minnesota particularly, that it be 50% or greater of the employee's pre-injury wage. In many states, the employee can decline the transitional job and not risk forfeiture of benefits, wage loss benefits, if the other location that you're offering is more than 50 miles away from the original location. So there's a geographic issue. If the job being offered is outside that 50-mile radius, a refusal of that job may be deemed to be a reasonable refusal. Also, just be mindful of child care or dependency care issues that might rightfully preclude the employee from being able to accept that transitional job offer. So in other words, if they had to care for an aging parent and they had that obligation before during standard day hours, then it would be deemed to be a reasonable refusal of that job if you offered it during those daytime hours. So just look for ways to modify the employee's workstation or existing job to fit within the employee's medical restrictions. And remember that the job does not have to be the exact same job that they enjoyed at the time they were injured. So if you find light-duty jobs such as filing, painting, other jobs on the at the work site, that's completely acceptable as long as it complies with their restrictions.